You can start.
Yeah. So, ladies and gentlemen, good afternoon and welcome at this workshop on AI and liability. My name is Hans Ingels. I'm the head of unit of the unit responsible for free movement of goods and product liability in the European Commission. Before I present the panelists, I would like to inform you that this will be an interactive workshop in which not only the panelists will be able to speak, but also you can share your views. So you can ask questions, you can vote in the poll during the discussion, and you can also react to the already posted polls. So for this event, we use Slido, so you can search the event with the hashtag AI Alliance, and then you select room W4 AI and liability. So welcome at this workshop. I'm very pleased to have 5 excellent panelists, experts in liability on AI. The first panelist is Karina Schulze. Karina is Director of EU Government Affairs for SAP. She is responsible for public policy matters related to the digital economy, data protection, cybersecurity, and export control. And her fields of expertise are indeed data protection, privacy, law enforcement, and cybersecurity. So welcome, Karina. Our second panelist is Marco Bona. Marco is the general board member from PUPIL, is a pan-European organization of personal injury lawyers. And he is an international personal injury expert and co-founder and senior partner at the Turin-based law firm of Bona, Olivia and Associati. Our third panelist is Professor Bernhard Koch. Bernhard is professor at the Department of Civil Law at the University of Innsbruck in Austria. And Bernhard is professor of civil and comparative law. The fourth guest is Professor Jean-Sébastien Borghetti. He is professor of private law at the University of Paris II Panthéon-Assas. Jean-Sébastien is specialized in contract and tort law in a comparative perspective, with a special interest in product liability, a subject that he has been researching for more than 20 years. And our fifth guest is Dick Stadelmeier, Dr. Stadelmeier. He's the head of unit of contract law in the Justice Department of the European Commission. So thank you to all the panelists for being here. And so participants, if you have remarks, questions that you would like to the panelists, then please do so in Slido. It would be good if then you could ask to which of the panelists you would like to ask a question. So, panelists, my first question to you is, what are, in your view, the most important shortcomings of the Product Liability Directive and national liability rules or national liability rules with respect to artificial intelligence? And so the first speaker, the first panelist who can answer this question is Karina Schulze. Karina.
Thank you very much, Hans. Thank you for the kind introduction. Thank you for having me here today. I wanted to clarify one point. I'll be speaking on behalf of Digital Europe, but as you said, I work for SAP, an IT company which is headquartered in Germany. So it's just to give a bit of the context and also a bit the flavor of where I'm coming from, right? And I actually wanted to start, when it comes to the shortcomings, I wanted to start with the national legislation, an outlook on the national legislation. For us, for this debate, our starting point was really the report from the EU expert group on liability for new technologies, and we have Bernhard here from the group. We found that actually very comprehensive and very, very helpful, this report, because it really showed to what extent we already have legislation in place at national level applying to AI today. I named just but a few to set the context. So we obviously have consumer protection tied to product and safety rules. We have strict liability schemes for high-risk scenarios combined with mandatory insurance, general liability rules, even also, or in the case of Germany, we have joint and several liability in case that different producers and developers come together. We have tort law. We have contractual obligations as well, very important for us as business-to-business company. We shouldn't forget about that. And not to forget, we have data protection laws and privacy legislation in place as well. So we believe that all these rules must be taken into account when determining to what extent gaps exist. And this is really important for us to address the gap, because we would like to avoid duplication of legislation or overlapping legislation. Before I turn to the specific, I would like to point out that we see AI as a technology, really as a vast array of technologies, not a single technology. I think this is something that is really important to keep in mind when we discuss liability rules, that it's a diversity of emerging technologies that is also very diverse in use and application. And hence, it's also very challenging to address the diverse range of risks. And it makes it more difficult to come up with one single solution. So this is really something that should be also kept in mind, that we are talking about very complex, different scenarios here. So I'm going to tap into, let's say the usual suspects that come up when we talk about liability. My first point will be on strict liability. I mean, there's been a lot of talk about the need of additional strict liability schemes. We would not just dismiss this, but we would certainly say that it should apply for very specific high-risk scenarios and cases. We think that's important. And one other important aspect here is to really understand who has the economic and social benefit from applying this high-risk AI or technology, who's using that technology and who's applying the risk. And according to that, we should also allocate the liability. In addition, it is very important to identify who has what kind of responsibility and who can control which kind of risk. Another aspect that often comes up is the question of, do we need a reversed burden of proof, separate obviously from strict liability? We also here, we believe this is a very, very sharp tool, right? And also should be only considered in limited cases in a very specific context. One can consider it when it's truly impossible or prohibitive for the victim to prove and come up with evidence. And we should, in those cases, one can look at facilitation of proof. One last point I wanted to make in this context is that we very much agree with the expert report that we don't believe that it's necessary to give devices or autonomous systems a legal personality. We believe that harm that's been caused can really be attributed back to existing persons or bodies, and we should not consider this outside of human control. So now, lastly, I'll come to the Product Liability Directive. We believe that it sets out a very clear and well understood set of time-tested rules, which are technology neutral. And that, again, is very important in this discussion. And it relates, obviously, to products and consumers. We actually think that the fact that the PLD has been in force for over 30 years shouldn't be seen as a weakness, but it seems to be a strength. You know, it's been standing the test of time, and was functioning very well, and took into account many changes and also the uptake of digital technologies. So we believe that the balance that is currently being achieved here allows for the development of new innovative products while providing protection and navigates liability risks in a fair manner, I would say. I'll stop here. I hope I didn't go over my 5 minutes, and look forward to the discussion. Thank you.
Okay, thank you very much, Karina. Very clear. Marco, you represent the Pan-European Organization of Personal Injury Lawyers. You've got a different perspective. What are, in your view, the most important shortcomings of national liability rules and the Product Liability Directive?
Right, many thanks. It's a privilege to be here with you today. Hope you can hear me well. Now, first, the shortcomings of the Product Liability Directive. Well, I would say that the first issue is the scope of the directive itself, because it concerns the liability of producer only. So whenever we have to face an issue with operators, users, owners of artificial intelligent artifact systems, there we may find some issues. Second, there is another limit to the scope of the directive, which is that it concerns the protection of consumers, while it does not address more in general the redress protection of victims. I mean, consumers and victims are two different categories. Sometimes they may overlap, some other times they may not. So this is a first issue. The second set of shortcomings is concern the directive itself. Of course, it's a good directive, now there are 30 years of application, and so there are many benefits in terms of protection of victims under this directive. But even in relation to, let's say, traditional products, some problematic issues arose during the litigation, and there are some critical issues. In general, of course, it is very difficult to go into details, but we agree within our group with the findings by Andrea Bartolini's document, which was recently published in July 2020. The document Artificial Intelligence and Liability, which was commissioned by the European Parliament Committee on Legal Affairs, and it was published in July. And there are some problematic aspects. Of course, there will be more problematic issues in relation to artificial intelligent artifacts and systems. Among these problematic issues, I would list the notion of defect that sometimes may cause some troubles. And I can confirm this point in everyday litigation where we apply the Product Liability Directive. There are some issues concerning the notion. There is an issue with the distinction between product and services. Okay, the directive tends to cover only product and not services. So this distinction in relation to Internet of Things, software, etc., may give rise to some problems in the future. Of course, there is the development risk defense, which is something that is a really problematic issue. And then the last issue is connected with the absolute time limit of 10 years. Okay, under Article 11 of the directive. 10 years is maybe fine with traditional products. I'm not certain that it would be fine and it would work in terms of protection of victims in relation to some artificial intelligence artifacts and systems. Okay. So these are basically our views in terms of shortcomings of the directive. So we haven't got a critical view of the directive, but we think that the scope is limited and maybe we should look for something else. And then I will get back to this point in the second part of my speech. Coming to national systems, well, of course, it is very difficult to address this issue in a very, very limited time because there are many divergences among the European systems, and Bernard is a maestro as to this issue, so I'm not going into details, but of course, there are also interesting cases where under national systems, there is already a potentiality of protection of victims under very old schemes of liability. And if I just consider my own country, so Italy, and we have liability regimes which are very old. They are more than 80 years old. I mean, and that are really they look as being perfect for addressing artificial intelligence damages. For example, I can quote Article 2051 of the Italian Civil Code, which provides for liability for damages caused by things under custody. And there, the rule is that everyone is liable for injuries caused by things in his custody, unless he proves that the injuries were the result of a fortuitous event. Okay. Now, there we have a rule which is already perfectly designed to address part of the problem we are talking today. I mean, the issue of liability of owners, operators, users of artificial intelligence artifacts. So, of course, I will say that the shortcomings of national systems are that maybe there is a lack of uniform rule throughout Europe, but in certain systems, at least the civil countries' systems, I will say that there are general rules that are already quite efficient in addressing this issue, and I'm sure that also our French colleagues can confirm this point in relation to the French model, but also the German model shows some general rules already addressing this kind of liability. Okay.
Okay, thank you very much, Michael. You stayed within your time. So let's now look. Let's now turn to the academics here. Bernard, you're a professor in liability law at the University of Innsbruck. Could you tell us what are, in your view, the biggest misfits between artificial intelligence and the current liability?
Well, thank you, Hans. I'm sure that Jean-Sébastien will say more about the Product Liability Directive, and I can tell you up front that I agree with everything he will say even before hearing him. However, it is fairly obvious to me, as already been said earlier, that the key shortcoming of the PLD as it stands is the lack of clarity regarding the definition of products and whether it includes purely digital products as well. In fact, I think there is a universal accord on this point in the meantime. This is not only a problem with regard to their online circulation, where the recent Digital Content Directive may buffer at least something, but also and in particular with respect to embedded software, therefore, where the data are components within the meaning of the directive. This is also the point I think most relevant to AI, as it will typically, though not necessarily, be just a component of another product. Even if one should prefer to have digital products excluded from the scope of the directive without suggesting that, it at least needs to be made explicitly clear once and for all. Another question already raised by Marco is the development risk defense, which, should one opt to stick with it, would also need further clarification. After all, the accessibility of information nowadays, as compared to 1985, has dramatically changed the answer to the question what the state of scientific and technical knowledge is at any given point in time. Two more problems are not peculiar to AI, which, as I'm just mentioning them, the unfortunate €500 threshold and the 10 years extinction period that Marco already mentioned earlier, which I think is clearly in violation of the European Convention of Human Rights when it comes to personal injury. When it comes to national liability rules, the biggest problem, I think, lies in the significant diversity of domestic tort law regimes, as both speakers before have said. The starting point in the law of delict in all countries is, of course, their historic core, as already indicated by its name. But even though fault liability is available everywhere, the actual application thereof differs as well, including, but not limited to, the definition of the standard of care and the preparedness of courts to adjust that standard or even reverse the burden of proving fault. The biggest challenge in an AI context, however, is much more basic. AI systems, by definition, do not behave in a human sense. So the flawed conduct that triggers fault liability would have to be solved outside of the AI system itself, be it in the sphere of the operator, be it in the sphere of the manufacturer or the software developer. And this is where the challenges for claimants lie in particular, connecting the dots backwards from their damage to an origin somewhere beyond the black box of the AI system. And in light of the unpredictability and randomness of some of the AI processes, it will be tricky to even use prima facie evidence as a workaround, since that requires safe, experience-based knowledge about what typically happens in similar cases. And the mere use of AI as such will not suffice. The problem of convincing the court of some fault within the sphere of the defendant can be avoided in a strict liability regime, of course. However, this is where European jurisdictions perhaps differ the most, if one disregards the remedies side. Some countries have general clauses triggered, for example, as Marco just mentioned, by things or by dangerous objects or dangerous activities. Now, whether or not the operation of an AI system will indeed be qualified as such by the courts is yet to be seen. Other countries rely on a piecemeal combination of individual statutory regimes. And apart from drones or autonomous cars, which are already addressed by at least some of these domestic regimes, I think it would require legislative intervention to expand the range of strict liability in those countries. And even in those places where such systems are already in place, they differ when it comes to details, such as the relevance of contributory conduct of the victim or the list of victims eligible to benefit from such a regime. Just look at motor vehicle liability at the moment. There is a crazy diversity all over Europe in this respect. Yet other jurisdictions have very little sympathy for liability without fault altogether. So I think the biggest challenge lies not so much on a purely domestic level in an isolated view, but looking at the jurisdictions where AI systems will be marketed in comparison. That was all I wanted to say.
Okay, thank you very much, Bernard. Very clear. Jean-Sébastien, you're also an academic, you're also an expert in liability law. What's your perspective? What are the main problems here for national rules and product liability directive?
Thank you very much, and thank you very much for this invitation. So I pretty much agree with most of what has been said until now, and especially on the remarks on national law. On the issue of national product liability rules, I would only maybe just to add on what Bernard and Marco have already said, that I think the shortcomings of those national liability rules depend of course, on the characteristics of each national law. And as a general rule, the more it relies on fault liability, and the more a national legal system may find it difficult to offer efficient tools to victims of artificial intelligence deserving compensation. For example, if you take traffic accidents involving autonomous vehicles, legal systems which still rely exclusively on fault or negligence liability, and there are some, well, not many in continental Europe, but that is the case, for example, of England, those regimes clearly need to adopt new rules for autonomous vehicles, and that is indeed what what England, for example, has already done. On the other hand, if you have, well, in countries like France, which already has a very strict liability regime for traffic accidents, that applies as soon as a traffic accident involving a motor vehicle has taken place, then you obviously don't need a new regime to address the challenges set by autonomous vehicles. So you've got very contrasting situations depending on the legal systems. If now I turn to the Product Liability Directive, I think I would identify 2 points which need clarification and 2 serious shortcomings. The first point needing clarification has already been mentioned by Bernard, and it's, of course, the definition of product. Does an algorithm or does data qualify as a product in the sense of the directive? And I think everybody agrees that this point needs to be clarified even if, I mean, you can already, of course, suggest an answer, but a clarification is clearly needed. I think a second, perhaps less problematic issue, but which nevertheless needs clarification, is whether damage to immaterial goods, such as data, is covered by the directive. The answer is probably no right now, or whether Article 9 of the directive seems to leave it open to national laws if they want to include or not to include damage to immaterial goods as part of compensable damage in product liability. But I think this point also has become very important and needs to be clarified. Now I turn to the shortcomings of the directive. I think the first and obvious shortcoming has to do with the central notion of defect. And I agree with what has been said, but I wonder if the real issue is the definition of defect, which is admittedly extremely vague, but I don't know if we can do better, or in how we assess defect. The real problem is, how do you assess defect? And it seems to me that for ordinary products, so like ordinary consumer products, you usually assess defect in one of two ways. One way is when the product malfunctioned. And when a product malfunctions, for example, if you turn the key, the ignition key of your car and the car explodes, that's an obvious malfunctioning, and normally there's no problem in agreeing that the car was defective. So that's one way. The other way is by comparing the product with similar products, with products which are comparable. So for example, if passengers of a certain car model often get severely injured in case of a lateral shock, and if it's established that passengers of comparable cars do not, then this might lead to the conclusion that the first model is actually defective because it doesn't offer the same safety as the one of, let's say, standard comparable products. The problem with artificial intelligence is that it is very difficult, I think, to apply those, I would say, standard defect assessment methods. And it is not obvious what other methods could be used. So to put things more clearly, it's hard to know what a defective artificial intelligence is, and it's hard to fathom how defect in an artificial intelligence could be demonstrated. And just very briefly, the second shortcoming, I think, of the directive, which already has been mentioned, has to do with the time element, and I would say also with the putting into circulation notion, which is an important notion in the directive, which surfaces at several places. And when you take an ever-evolving product such as artificial intelligence, then it's problematic to retain a single putting into circulation date. And of course, putting into circulation has an impact on several aspects of the regime, including the so-called development risk defense. That's, I'll stop there for now.
Good. Okay, thanks a lot, Jean-Sébastien. And last but not least, Staudemeyer, I had a contract law. I was very much and actively involved in the new technologies formation of the expert group on liability and new technologies. So, Dick.
Thank you very much, Hans. Thank you for your kind introductory words and the presentation earlier. To answer the first question, so what are the important shortcomings? It's probably important to look at, it has already been mentioned by several participants, but look at the traditional structure of a liability claim. What does a victim have to prove in order to have a successful claim? And basically, there are in almost all laws, despite all the differences in extra-contractual liability laws, more or less the same criteria. The victim first has to identify who the potential liable person is, against whom it can address its claim. And then it has to prove an action and a fault of that liable person. It has to prove his or her damage. And it has to prove a causal link between the faulty action or omission of the liable person and the damage. That's more or less common ground among all national laws, all member states. Now, this was a starting point for the Commission report, which was accompanying the white paper. We looked at these commonalities of national laws. And basically, then we looked at the specific characteristics of AI to see whether and which these specific characteristics challenge these commonalities of national liability laws. I do not have to go into the technical details, but basically the two of the most important specific characteristics of AI, which the report and the white paper mentions, are autonomy and opacity. And now looking at how these challenges the national liability laws. Well, opacity is the kind of, without going into details, but we can afterwards in the discussion, kind of also called black box effect. It's the question to demonstrate how you come from a certain input to a certain output, which leads then to a damage. And autonomy describes the fact that there is, in the sequence of events, somewhere an autonomous decision of the algorithm which interrupts the normal sequence of events and makes it very difficult to trace back from the damage going back to an output, to what happens, that's the opacity element, to an input, to a human action. And so basically, these are the main challenges. And these challenges combined have the effect that for a victim of possible damage and a victim who wants to raise a liability claim, a possible liable person, it is first of all very difficult to find out who the liable person is, but then even more difficult, if not impossible, or at least prohibitively costly, to prove the fault and the causality, and therefore then attribute a faulty behavior or a specific outcome to a human action. So basically, these are the two main challenges we have to deal with. And obviously, looking at those challenges does not mean that we have now to review the entirety of extra-contractual liability laws, which are very, very different, as, for example, Bernhard already explained earlier. No, basically, we have only to deal with those AI-specific characteristics which create these specific challenges to liability law. And that's basically what the Commission report and the AI white paper have put forward for consultation. Thank you very much, Hans.
Thank you very much, Dick, and thank you very much to all panelists for very clear presentations. I see more or less a consensus about the problems that you are raising. Now, my question to you: if you would be, let's say, President of Europe, how would you then reform the rules on liability to solve the problems with AI? And these rules of liability could be public liability rules, but of course be the national rules. So what would you do? You, the expert, you would be now suddenly President of Europe. Now, the first president that we would be having would be Karina Schulze. Karina, how would you solve the problem, the legal problem of liability and AI?
Okay, well, easy question. So I would say, based on everything that was now said before, I think going forward, first of all, realistically, I try to be a realistic president, right? I think we should accept that for really the time being, we will have European legislation, but also national legislation in this context go hand in hand. I don't think that it's really realistic to believe although we are a big fan of the digital single market, and we are certainly a big promoter of having more harmonization, but looking at the complexity, and also something we heard before, these systems have grown. The schemes have grown, and they've been out there for years and years, and I think they cannot be easily replaced. And it would also create a lot of legal uncertainty. So I would say important is to understand that these schemes will go hand in hand. Now, taking it from a victims and consumer protection perspective, if you look at companies, we now want to develop, new AI systems and new innovations. I would feel more comfortable if I knew that there's already something in place today which can protect me. So I think it is really, really important that while we should be looking at the shortcomings of legislation, we should really understand what is there in terms of protection already today, in order to enforce it. Because this notion of, trying to find gaps and seeing gaps sometimes diverts from the fact that there is legislation out there and legislation that can be enforced. But if we look the other way, we're also not going to enforce it. So I think it's really important to make sure we understand what is already in place in terms of protection today, and I'll come back to that. I think I was a bit alone in my rather positive outlook on the PLD. Other speakers obviously were a bit more critical. I would just like to say one thing. If you the necessity to clarify the scope in general, I fully support that. However, clarifying doesn't necessarily mean extending, right? So and the idea of, or the problem of software, yes, I understand that as well. That when it's embedded, I also fully understand this. And I think there was a lot of development in terms of medical devices where embedded software, absolutely, it's part of the product and it falls under it. I see it a bit differently for standalone software, I think, and also obviously, if we move away from the consumer protection to the B2B sphere, that's also very, very critical. I wonder if we wouldn't be opening a Pandora's box there, right? If we take standalone software, if you come to think of it, what is the problem with software today? It's being developed, it's very fast, but then you think you have a safe software out there and then it gets hacked. I mean, there are so many unknowns in the whole software development cycle, which should be covered and which should be taken into account. But I wonder if, the Product Liability Directive is the right context to do this. So I would caution a little bit to extend the scope. In a, let's put it that way, unreflected manner to software. I think we might be opening a Pandora's box again, also to us. We have many legislation today in place that is addressing security of software already. So in cybersecurity legislation, this is certainly an important factor. One last point I wanted to make, again, with respect to already existing legislation, I would just throw out one idea here, which is in terms of immaterial damage and data, for example, reputational damage in the context of AI. I would really say, let's have a look at the General Data Protection Regulation. Back to my point, let's look at existing legislation. I think when it comes to personal data, and in most of the cases, personal data is involved, one could look at the remedies that exist under this piece of legislation. So again, my plea at let's not believe there is a quick fix, right? I said that before. We're dealing with very, very complex, different situations. We will not have a one-size-fits-all solution. We're not going to have a quick fix. But that also means that we need to draw on what is existing already today. And again, I think this is an additional layer of protection that is already out there and that also can be enforced. And I stop here. Thank you.
So thank you very much, Karina. Very clear. With very short career as European president, now we'll have another European president who now has the privilege to reform national and European liability rules. And so, Marco, what would you do if you had the honor and the privilege to make a big reform of liability rules?
Well, it is always very difficult to make plans for the future, and here we are talking about the future. But because I'm a father of a little child, then I have to worry about the future, and I think that the future should be rationalized. And whenever you talk about rationalizing liability, especially in the perspective of the European Union, you are talking about harmonizing liability, and it is. And so, when you address harmonization, first you have to take care about the general principles of liability, and then you can go on discussing about special issues. But I think that it should be we should approach this issue also addressing the general principles of liability, because otherwise the risk is that we go on creating different areas of law. So the product liability directive, then there will be rules for privacy, for every. But the risk is that there isn't a rationalized system, and so the risk is the uncertainty of law, and also to jeopardize the protection of victims, but also the evolution of technologies. So I think there should be a debate about the future of European Union tort law. But apart from, I mean, this general perspective, so I think that, of course, a part of the plan of our future is a plan for liability. And I also would like to say that, by the way, liability is not against innovation. I mean, liability can promote better innovation. Now, getting to your two answers, I mean, about the product liability directive and the national system. First, as to the product liability, I would not suggest to reinvent the wheel. Okay. The product liability is already there. It should be amended, better clarified. For us, for Peopila, there are at least 4 points that should be reconsidered. First of all, it is the requirement for the victim to prove the defect, in addition to causation. For us, it would be sufficient for the victim to prove causation. I mean, that certain product has caused the damage. Then it should be up to the producer to prove that that the damage was not caused by the unsafety of the product. Secondly, it should make clear that for a claimant, it is sufficient to allege that the product was unsafe. There is always a margin of discussion in everyday litigation as to the difference between defective product and an unsafe product. And in practical terms, it is sometimes difficult to make a judge understanding that we are talking about the same notion, okay? Which is also made clear by the directive, but not every judge reads the directive in a correct way. Then, of course, I will say, well, I already said that I would amend the 10 years absolute time limitation period. I totally agree with Bernard that especially in relation to personal injury, and that time limit is against fundamental rights. But I would say that it is also against fundamental rights in other areas. For example, whenever you talk about personality rights, reputation, etc. So it's then I also would go back to the concept of putting into circulation, okay? Because in relation to some artificial intelligence artifacts, systems, they may become something different. There may be alterations that take place during their autonomous life, and so limiting the liability of the producer to the moment when the product is put into circulation, that may limit too much the liability of the producer. So this is our views as to the Product Liability Directive. Then, as President of the European Union, of course, I would be very optimistic, and by the way, I would fight for a common European Union liability regime addressing the issue of operators, the liability of operators, users of artificial intelligent artifacts. And I would be in favor of a strict liability regime because we need that kind of approach for the victims, especially when they have to deal with products that are very difficult to be understood, and so it would be wrong to place the burden of proof of fault of the defect of the product on claimants, victims. So I would think about a strict liability regime, and I think that it is very interesting the recent proposal for a regulation by the Commission of Legal Affairs of the European Parliament. I mean, that kind of model is very interesting. Although I will say that there are few critical issues about that project, and we disagree.
Michael, you have 30 minutes.
Okay,
30
yes.
seconds.
Well, I just gave 2 points about this proposal. We disagree with basing the uniform regime on the distinction between low and high risk technologies, because that may create confusion. Second, we disagree with limiting compensation to some specific categories of damages. For example, with the exclusion of immaterial damages. Immaterial damages are becoming much more and more important for the protection of victims, not only in the field of personal injury, but also as to reputation. And so we shouldn't forget that issue, as also Karina said earlier on. Thank you.
Thank you very much, Marco. We have little time left, only 11 minutes. So, Bernard, if you could change the liability systems in Europe, national law and product liability, what would you do? You've got essentially maximum 3 minutes. Bernard.
Well, as to the directive, as has been said, it needs a clarification of digital products, of course, and it needs further explanation of the development risk defense. But it really depends on whether that will happen into the direction of including digital products. If that were the case, the real challenge will be, of course, to align it with the underlying concept of the original PLD, which had products in mind that are final once they leave the manufacturer's door, which is why the moment when the product was put into circulation is so crucial. And as Jean-Sébastien said earlier, this doesn't work with software, which is constantly being updated with the original manufacturer not giving up control and influence at all after distributing it. Sometimes these updates go so far as to completely exchange the original product with an entirely new one. It would therefore be necessary to distinguish such products from the ones the drafters of the original PLD had in mind. One would also have to take into consideration that this ongoing process of updating can be influenced by the product user if she blocked such updates, for example. Another important item on the to-do list would be to address the interplay of multiple producers contributing to the product after it was put into circulation. I'm thinking of products with embedded AI whose operation requires the interaction with other digital content from third-party producers. Setting up a separate liability regime for developers and other producers of digital products only alongside the current PLD would trigger substantial problems of drawing the line, as we've already experienced in the discussions around the recent Digital Content Directive and the Sale of Goods Directive, which is why I think it makes more sense to amend the PLD, even though this would probably expand its wording substantially. After all, modern cars are clearly products within the meaning of the PLD, even though most of their defects nowadays already are less hardware than software related. From a legal policy perspective, I think it still makes sense today to channel liability for AI systems onto the manufacturer, who is in control of the development and the best player to ensure the risks of the product itself. This is particularly true for producers of a final product with embedded AI, where a defect may arise from the mere combination of hard and software, with the user absolutely unable to identify where the defect originated. And it also makes sense from a business perspective. If liability were on somebody else, the developer of the algorithm would have troubles keeping it secret, because if someone else were burdened with proving causation, they would most likely be granted access to the sanctuary of the code. Now, Karina Schulze earlier said that this is not a problem, but I'm not sure. This does not mean, however, that the producer should be the only possible addressee of claims raised by someone injured by an AI system. There are accident scenarios where it makes more sense to focus on the immediate user of the system, i.e. the person controlling and benefiting from its use. And this other defendant could then pursue a potential recourse action against the producer if the true origin of the accident can be attributed to the latter sphere. I'm thinking in particular of self-driving cars, of course, where we already have a more or less well-functioning motor vehicle liability insurance regime in place, and where we will see a long phase of both conventional and self-driving cars together on our roads. We tried to address that in the final report of the expert group by distinguishing between so-called front-end and back-end operators, a distinction apparently now also endorsed by the Committee on Legal Affairs of the Parliament. Now, I'm almost out of time for national liability rules, but I think the crucial to-do list there lies in the interplay of a possible harmonized regime with existing tort law. After all, for the sake of equal treatment and fairness, it's always hard to justify why some victims are treated better than others. Just think of imposing strict liability for autonomous vehicles into jurisdictions that do not have an equally victim-friendly regime now for conventional cars. How could you possibly justify that a pedestrian hit by a self-driving car does not have to prove fault, whereas if she were injured by a conventional car, she would? This is even more true for tampering with the details of compensation. So I think this should be done with very careful analysis of the existing tort laws. On the other hand, I think and I fear that there is already a considerably large Pandora's box out there already with existing tort laws in place, to use Karina's metaphor. And I'd rather open it before, or at least try to find out what's in there. So that's all I can say in that short time. Thank you.
Thank you very much. And I'm very sorry that we don't have more than 60 minutes. We could spend the entire day on this discussion. So very clear and very concise. Jean-Sébastien, you've got 2 minutes. Could you tell us which changes would you make to national rules or to the Product Liability Directive?
Well, as far as national law is concerned, it seems clear to me that it wouldn't make sense to develop purely national regimes which would apply specifically to artificial intelligence. First of all, it's doubtful if a one-size-fits-all solution is adapted to AI, as has already been said. And we already have a general regime which is potentially applicable, and that's the Product Liability Directive. So then if we turn to that directive, I think it should be made clear that standalone algorithms are covered by the directive, at least if they're not tailor-made. And so the notion of producers should be adapted accordingly to cover those who basically put into circulation an algorithm. I've mentioned immaterial damage, which I think is an important point. But of course, the main issue, I think, is defect. I have explained the shortcomings of the notion, but I think that it's also very difficult to do without it, because a purely causal liability would hardly be acceptable. So what can we do? I don't have a final answer, of course. Part of the solution probably lies in a presumption of defect, which could apply in some specific circumstances. For example, in sectors where the accidents rate is or should be extremely low or low, and where accidents have potentially very serious consequences, such as, for example, traffic accidents, then it might be presumed that the accident was caused by a defect, and it would then be for the producer to prove that the artificial intelligence was not defective. And also, as has been suggested by several authors, a presumption of defect could also apply when the producer does not or cannot give enough information on the functioning of their AI. Yeah. And then the last point, of course, has to do with the time frame putting into circulation. So I fully subscribe to what Bernard has said. I think it must be made clear that, the development risk defense must also be clarified in the context of AI. And the 10-year delay, of course, is also a problem, and I think should be changed, at least for personal injury.
Okay. Thank you very much, Jean-Sébastien. We're running short of time. So,
Hans, we can't hear you.